Good evening, ladies and gentlemen. This side, Rahul Magan here. And also a second year law student. Today, the video which I am making is a hybrid video, which means I would not only be interacting as a hedge fund, but I would also be interacting like a law student. But this is amongst a very rare video which I made where rather than telling a solution or raising a point, I am raising a question of law. You know, guys, as a second year law student, in law we are having two things, either as a question of law or a question of fact. Honorable higher courts like High Court or the Honorable Supreme Court of India, they generally deal with the question of law. It is said that a thing which is decided by Supreme Court is the law of the land, which is technically known as Article 141, which is called binding precedent. So, before I take this matter further, I once again repeat that I am raising a question of law. It may be possible that after few months I get a resolution of that or a near resolution of that. But having said that, today, which is 23rd October 2023, I do not have a resolution to this problem. But before I speak, let me thank you very much to a very wonderful person who wrote this book. I referred this book, and this book is called Trust and NGOs, and this book is by Taxman. On time-to-time basis, I am buying the Taxman book on the various topics, and I am finding it very, very useful because the kind of language they are using, it's really helpful. And so I request Taxman to please accept my appreciation. Apart from that, there are two other books which I am using. Number one, the BEAR Act, which is called the Indian Trust Act 1882. And secondly, which I'm using, the CPC, which in our parlance is known as Code of Civil Procedure. Ladies and gentlemen, I told you that in India, there are two kinds of investment markets or bodies. Number one is definitely the CIS. By CIS, which means something which is public, mutual funds, and all these institutions where things are public, CIS. Another is a private entity, an entity which is known only to few people, where the fund activity is known to few people. It may or might not be known except to few people. And this industry is called AIF. AIF means Alternate Investment Funds. Please be note that Alternate Investment Fund is derived from a word called PIV, which is called Pooled Investment Vehicles. Tactful speaking, pooled investment vehicle is of two types. Number one, the private pooled investment vehicles, and here comes the alternate investment funds, and the public pooled investment vehicles like unit trust, LIC, where majority of the information, mutual funds and all where things are public. Now, according to the statistics in the public, majority of the alternate investment funds in India are founded as a trust. You can form alternate investment fund in India either as a trust, as a company, or as a LLP. Now, it is up to the founder or the partner or the investors or the sponsors. They have to make a joint call whether they want LLP, they want trust, or they want company. Now, the decision which they are referring is based on cost, disclosures, their own clarity issues, and many things. Having said that, today the question of law which I am raising is about a trust. Henceforth, the question on LLP, which is called Limited Liability Partnership, and the question of company is excluded from this video. I once again thank you to Taxman for such a wonderful book. I went to page number 46 of this book, and it is as under. It is a well settled principle of trust law that once a trust is created and has certain objects stipulated, even the settler has no power to delete any of the original object. Kindly take a note, the book is using that even the settler has no power to delete any of the original object. I know that the reference which is given in this book is of charitable trust, but I am still taking that reference. The Honorable Madras High Court in the case Shakti Charities versus CIT 1984-19 Taxman 100 held that it's a well established that a trust has been founded with certain objects. These original objects cannot be deleted even by the founder of the trust, though it is possible to add some other charitable objects without detriment to the original object, which means you founded A, B, C, D in your trust deed. You cannot delete that A, B, C, D, but you can definitely add E, you can definitely add F, subject to the fact that it should not be detriment to the original object. It means it should not be a conflict of interest, or it should not hurt, H-U-R-T, hurt the original logic behind the trust. The rectification made by trustees deleting some object was held non-valid as the deed didn't authorize them to do so. So this book is referring the trust deed from the angle of charitable trust. And I completely respect that. Thank you very much for that. But my question of law is altogether different. And this is the reason I raised the point linked with the charitable trust. Now, first of all, this book using a word called settler, and I would be coming to this word little later in this video. Alternate investment fund is definitely not a charitable trust. Number one, they are closed structure. The whole objective they are carrying in their mind is to invest in a relevant company, set of companies, probably a sector, probably some startups, maybe some incubated companies, maybe unlisted companies, or maybe all. That completely depends on the confidential private placement memorandum, which is called CPPM, which is signed between the sponsor, the investment manager, and also the original, basically the investors, those who backing the AIF. Henceforth, alternate investment fund cannot be termed as a charitable trust, because in worst cases also, we cannot trust this as a charitable. The sole objective of alternate investment fund is to make profit. But having said that, every trust which is designed by alternate investment fund, this trust should have a person called settler. Now, let me have a legal definition of a settler. A settler is the entity that establish a trust. The settler goes by several names. Example, donor, guarantor, truster, and trust maker. Regardless of what this entity is called, its role is to legally transfer control of an asset to a trustee. Please take a note, the definition which is using transfer control of an asset to a trustee who manages it for one of the beneficiaries, one or more beneficiaries. Now, the beneficiary would definitely be the investor, those who are investing the money. Why I'm not raising the point is that alternate investment fund in majority of the cases is closed for public, except few countries. And like I said in my earlier videos, I would be raising the laws of these countries as the time permit. The time is definitely an essence in most of the cases. It practically means that settler is an entity which establish a trust. Now, let me go to this book again and have a very, very important thing which is definitely there. In Kamla Town Trust versus CIT, CIT means Commissioner of Income Tax, it's a 1982 judgment. The question debated was whether the civil court has the power to rectify the trust deed under section 92 of the CPC. CPC means Civil Procedure Code. The court observed that section 92 nowhere enables the civil court to alter or rectify the terms of a trust. It only enables the civil court to, in suitable cases, to remove any trustee, appoint a new trustee, vesting any property in a trustee, directing any ex-trustee to deliver possession of a trust property to the person entitled to the possession of such property, directing accounts and inquiries, declaring that portion of the trust property or interest therein shall be allocated or allotted to any particular object of the trust or to settle a scheme. Thus, the court has got the power to allocate the trust properties to any particular field of trust. Any particular field of trust. The civil court had deleted from the trust deed certain object as to enable the trustee to claim the benefits of exemption under 1961 Act, which means the income tax. It was held that section 92 was not appropriate section or stat for the amendment of the trust deed. Section 92 CPC, I once again repeat, Civil Procedure Code. The court cannot give, the court can give a direction which is necessary for the administration of any trust. But it can only exercise the power expressively set out thereunder, and exercising the power under section 92, it cannot alter the object of the trust deed. It means the court can do various activities under section 92 CPC, but having said that, the civil court cannot alter the object of the trust deed. Now, I'm raising the question of law. Question of law is, can an alternate investment fund is allowed to change the trust deed assuming it is formed as a trust? Please take a note that when I'm using a word trust in my video, I am deliberately not using a word public trust or a private trust. Because if I start using a word public trust or private trust, then I need to explain that. So for the time being, I am keeping this point open. But my question of law, where I do not have any answer as we speak, but of course I am trying to do a lot of research, trying to see whether I can have an answer to this question or not, is, can an alternate investment fund change the trust deed which they made originally, or the settler of that entity or a trust, you call whatever you call, is authorized to change the trust deed? If yes, then how? If not, then how? That's very important. To understand my question, I went to CPC and I went to section 92 to see in case I get the answer of my question. So I went there, I went to section 92. Now this is the section 92 of the CPC. The CPC stands for Civil Procedure Code. Please take a note that when we read a law, it is always advisable to read a law from the bare act, then do a thorough research from the commentary, and time permits or do not permits, try to see the maximum judgments so that you have a better clarity on a law. Let's go ahead with section 92. In the case of any alleged breach of any express or constructive trust created for the public purposes of a charitable or a religious nature, or where the direction of the court is deemed necessary for the administration of any such trust, the Advocate General or the two or more person having an interest in the trust and having obtained the leave of the court may institute a suit whereby, contentious or not, in the principal civil court of original jurisdiction. Please note original jurisdiction. It is not a civil revision or a criminal revision. It's original jurisdiction. Or in any other court empowered in on behalf of state governments within the local limits of whose jurisdiction or whole or any part of the subject matter of the trust is situate to obtain a decree, which means that territorial issue is definitely there. Point number A, removing any trustee. Point number B, appointing any trustee. Point number C, vesting any property in a trustee. Point number C, directing a trustee who has been removed or a person who has ceased to be a trustee to deliver possession of any trust property in his possession to the person entitled to the possession of such property. Point number 4, directing accounts and inquiry. Point number 5, declaring what proportion of any trust property or the interest therein shall be allocated to a particular object of the trust. Point number 6, authorizing the whole or any part of the trust property to be let, sold, mortgage, or exchange. Next, settling a scheme. Next, granting such further or other relief as the nature of the case may require. It's a long thing, but one important thing which I would like to highlight here is that the court may alter the original purposes of the express or constructive trust created for public purpose or charitable or religious nature and allows the property or the income of such trust or portion thereto to be applied separate in one of the following circumstances: A, B, C, D, E, F. Now let me read A. Where the original purpose of the trust in whole or in part have been as far fulfilled, cannot be carried out in all or cannot be carried out according to the directions given in the instrument creating the trust, where there is no such instrument according to the spirit of the trust. You may please refer CPC and you are able to refer the whole, but let me go one by one. My point is simple. I created AIF as an example, and I wish to invest in a real estate sector. And what would? The real estate sector is facing losses. I decided to alter, as a settler, I decided to alter the trust deed, and now I wish to invest in IT sector, assuming, is that possible? I have no answer to it. Point number B, where the original purposes of a trust provided a use for a part only of the property available by virtue of the trust, where the property available by virtue of the trust and other property applicable for the similar purposes can be more effectively used in conjunction with and to that end can suitably be made applicable to any other purpose, regard being had to the spirit of the trust and its applicability for the common purpose, and the respective points which we have. My point is very clear and very straightforward. When I read this whole, then very clearly I am able to see that this section is designed for public purposes, which means public purposes of a charitable or a religious nature. Unfortunately, I have not been able to see whether the specific purpose trust, which is called alternate investment fund, who are nowhere public in nature, completely confidential, and of course they have their own say why they are confidential. I am not making any statement on that. Whether the settler is able to change the trust deed or not, that's more important. And another thing, whether the settler holds the power to ask any investor. So suppose there is a AIF called ABC, simplistically, and in this APC there are 6 investors, assuming, and out of 6 investors, the settler, suppose his name is X, the settler decided to remove 2 investors and bring 2 fresh investors on the board. The 2 investors which he is removing, he is having his own say, agree or disagree, that is separate. The 2 which he is trying to add, on this also he holds his own say, agree or disagree, that is separate. But having said that, whether the guidelines provided in CPC, which is Civil Procedure Code, or the guidelines provided in the alternate investment funds, whether these guidelines are allowing the trust settler to make this happen or not. I do not have an answer to this question. Alternate investment fund is one of the finest topic which is close to my heart. And I strongly believe that there are few alternate investment funds who are doing a wonderful job, at least I can say. And having said that, there is a well more than sufficient money invested across the globe in the alternate investment fund. There is hardly any day passed when one or another information is not coming about alternate investment fund worldwide. But ladies and gentlemen, this question of law is something I wish to raise. Maybe in the later stages, I would have some judgment or maybe some citation, maybe some concrete document which can prove that the change is possible. But having said that, I am keeping this point open for the time being. But of course, this topic would continue to be in my diary for further research. I don't know how much time it will take, but having said that, I found out that this topic deserves a concrete research. How long it will take, I do not know. Thank you very much. This is Rahul Magan.